Dear friends, fraternity, brothers and sisters, I am Venkat Shivkumar. I made a video on our Honorable Chief Justice of India, Dr. D.Y. Chandrachud, and he's going to retire on 11th November 24th. What are his contributions? I'm focusing more on a great job done, access to justice. Being a person from Chennai, outside Delhi, the value of Lordship services with his companion of judges has been tremendous, which I would like to explain in my own way. And this I'm making four videos, 4 languages, this video: Telugu, Tamil, Hindi, and Marathi also. Now, dear friends, what is that I'm trying to say? Here, if you see, whenever you present your case before the Lordships, SLP, the first question they will ask is, what's your case? It might be bundles are there. They won't have time to listen. What is the substantial question of law you're trying to tell us? Yes or no? That's how the case goes. Now, if you ask me, what is that the Lordships have done for us in one shot? That you're asking, you're giving a name as father of the access to justice, such a big name. Now, friends, you see, these are the great people I've taken. Honorable Bapuji, the dear father of our nation, what he said is, where there is a law, there is life. Martin Luther King, injustice anywhere is a threat to justice everywhere. Then Baba Saheb, freedom of mind is the real freedom of life. Benjamin Franklin, it's very, very important, I took it. Father of Indian Constitution, father of our nation. And now I'm saying Honorable Justice DYC done a remarkable work as a father of access to justice. But I would like to add Benjamin Franklin to this. You all know he is the father of electricity. Of course, Michael Faraday was there, Edison was there, and then computers, Babbage has come, then protocols in the form of internet protocols, Robert, and then the 2 other persons. But what is significant for us is Benjamin Franklin did an experiment, you all know, that he put this thing and flew the kite, a small key, iron key. And when the lightning came in, electricity passed. Then everybody asked him, why are you doing all these sort of exercises, electromagnetic theory? Then he said, what I invented, I myself don't know. But I know only one thing. One day, this experiment is going to create wonders to a beautiful world that will happen. The same thing, Honorable Chief Justice and his companion of judges. But Honorable DYC has been there as a judge, the digitalization issue. He took it as his heart. Many things he has done. I'm not going into the judgments which Lordships have delivered, wonderful judgments. But when a judge delivers judgment, you can't expect 140 crore people to like it. Some people like me, some other people will dislike. And whatever is the judgment of today is overruled later. Of course, yes, wonderful judgments are there. I'm not going to that domain. But then a great service. This is the access to justice will change the color of our nation, the way of living. Today, where is the freedom for us? Suppression, oppression, and people are fed up with law, fed up with judiciary, and there is no justice in the system. And he tried his best. 2 years is a very eventful period. And now here is the question, how he functioned. Now, if you see, my dear friends, brothers and sisters, I have included the Lordships in the galaxy of the greatest people. You may like, some people may like, but everybody will one day will realize the amount of the work that has been done, and it's they're like, no, once it becomes a tree, only you get a fruits, but it's in the still the nascent stages. And a characteristic of a judge, one is the technology, how he harnessed with, not he means not necessarily he, but this leader who did this job. But now as a judge, he raised the question recently as whether I've done my job or not. It's worried and all. And in spite of doing such a great job. Now let's go to the judge and the dispensation of justice. We are going to the Dharma Shastras. A judge should be austere and restrained, impartial, restrained, impartial in temperature, steadfast, God-fearing, assiduous in his duties, free from anger, leading a righteous life and of good family. The foremost attribute of a judge is integrity, which includes impartiality and total absence of bias or attachment. Now, Lordship fits into this. You ask any person, nobody can deny. Nobody. There are two types of people will be there. One is the fraternity, the lawyers. Even the lawyers who practice in Delhi, practice in Bombay. Delhi practicing is different in Supreme Court. Bombay practice is High Court and lower courts. And then others in the entire nation, other parts of the nation. That is how you have to analyze it. But a great judge. And now, a judge should decide cases without any consideration of personal gain or any mind of personal bias. And his decision should be in accordance with the procedure prescribed by the text. A judge who performs his judicial duties in this manner achieves the same spiritual merit as a person performing yajna, Lord Shiva. It is a duty to Lord Shiva or Jesus or Allah. The sitting, the bench where you sit is nothing but the bench. Instead of the God has no time, therefore he deputed the judges to sit in the place and discharge his duty, because for God you pray and here also you pray. So the judge has to take that so sincerely that it's an opportunity that the God has given to him. And in the olden times, we know that the justice administration is based on the king, who is to have all the three power state organs, the legislature, lawmaking, and execution, and also adjudication, based on the advice that he receives from the ministers and rishis, saints, etc. And now we know there's a separate this doctrine of separation of powers and individual domain. And it is settled principle that the judge, the judicial, the judge, in the process of an interpretation, will set the law. Judge made law. The parliament may be making legislative law, but then through the process of interpretation, it is the judge who really makes the law. The American Supreme Court decided, as you all know, because justice without power is inefficient. Power without justice is tyrannous. So therefore, there is a balance that was created. And now we can see the greatest of the Chief Justices has said this in his role. And what exactly he said, we'll see that, the role of judiciary. And we'll go to that. Let us listen to Justice Bhagwati.
Legend. ఏం చేస్తున్నారండి?
Fortunately, in our country, we have the directive principles of state policy, which are the lodestar, the beacon light, which are supposed to guide all the three departments of the state in their activities. So the judiciary also is not on an uncharted sea. It is not as if the judiciary can do whatever it likes. Judiciary also has got to keep the constitution in mind. And the judges have got to be on the same wavelength as the constitution. That's why we select judges who are in tune with the constitutional objectives, who are imbued with the spirit of the constitution. Then I do not see any harm at all.
Now let's take to Honorable Chief Justice of India, Bhagwati has spoken about this constitution, and Honorable Justice Abhay Oka, the present serving Supreme Court judge, who is revered by almost every lawyer in the Supreme Court. What does he say about the judge, role of a judge?
But look at the judge. When you sit on the dais as a judge, maybe as a civil judge, maybe in any capacity, you enjoy more than 100% freedom. Nobody can, no power in this world can control what you do as a judge. Your power to decide is affected by only two things, which again depend on you yourself and not any external factor. One is your own conscience, and second is the legal position or legal provision. These are the only two small things which put constraints on you as a judge. And therefore, when you sit on the chair of the judge, you are a completely independent person. You have all the capacity and all the opportunity to rent.
Now we have seen the great people who spoke about the role of a judge, starting from Dharma Shastras, and then we took you through. The greatest judges are, most of the judges are so good. When you come to Supreme Court, you will be sure of getting justice. But then whether you will be able to go to Supreme Court and plead your case is the next question. That is called access to justice. And that is what the Honorable Chief Justice made it possible. I'll tell you with live examples. Now, friends, what is the justice administration system that everybody wants? If you see the speeches of everyone, but in particular our Chief Justice, outgoing Chief Justice DYC, he started with his goal itself, worked for that. So here is, I'm going to show you a 1 minute clipping where the justice administration system in the Hindu Dharma Shastras in 5th and 6th centuries. And it is a place of Madurai and Kannagi. before you can understand the Tamil language, I'd like to put it in English, where the helpless lady, her husband was beheaded. They came to Madurai to do some business, leaving their place in Chernad. This is Pandya's kingdom. And the misfortune is such that by one goldsmith, in order to cover up his theft, that his anklet will be there. Her husband will come with the anklet to sell something and start make a living by doing some business trade. But that goldsmith of the queen steals her anklet and tries to put the blame on this person who is an innocent person. And the king decides, saying that behead him. That's all. This is the story. In the mid of the night, Kannagi, the terrified, two things have happened. One is her poor husband has been killed, beheaded. Second is there is a branding that is a thief. And so she comes. And the king, that court was ready to hear at any point in time. That is the justice administration system in India. And she comes inside. They are all shocked, ministers. Then the judge will ask, what's your problem? And who is the accused and what is it the charge? Then the Kannagi says, accused is you the king, you are the accused. Two, the charge is you are a murderer. You have killed the innocent husband of mine and branded him as a thief. Then he says, what is the proof? This proof you should have asked that time, not after killing. The principles of natural justice, they were embedded in this. The access to justice. And you see the role of the judge. That's what Honorable Justice Abhayoka or Justice Bhagwati were speaking about. It is a yajna, dharma shastras. You do something wrong, you will be penalized. That is what everybody has to recognize as judges. So the judge will realize, the king who is exercising the judicial powers realizes that he's done a great mistake and he commits suicide in the name of God. That is what is the subject. And this is handled by the Honorable Chief Justice DYC exemplarily. But still he's got a doubt asking whether I've done my job correctly. His conscience. And that's what Justice Abhayoka said. You are responsible to your conscience and the provision of law, nothing else. And let us see.
அது பரவாயில்ல மாத்திரம் புரிந்த உனக்கு சேர்ந்த குலத்துக்கு இரு இடத்துக்காக உனக்கு அழு என்னை காலமெல்லாம் அழவைத்த காவலனே அழு என் காதலனை என் கண்ணாளனை கண்ணிருந்த மனத்தை துடிக்க துடிக்க கொண்டு அழு அழு
உன் கணவன் கல்வனன் ஆராயாமல் அவசரத்தில் கொண்டு வருகிறாமல் என்று ஆணையிட்ட நானே கல்வன் தமிழே தாயகமே என் தாயே என்னை மன்னித்து விடம்மா என்னை மன்னித்து விடு.
Now, this is a background on the position. The highest court of land is 140 crores of this great nation, and the judiciary's head is the Hon'ble CJI. Something everybody knows is the small thing we are talking. The parents of the current Chief Justice of India, DYC, are a illustrious Chandrachud, who was our Chief Justice earlier, and a mother, Prabha Chandrachud. YV Chandrachud, the 16th Chief Justice of India and the longest serving Chief Justice in the country's history. He was born in Pune in 1920 into a prominent, his father, into a prominent Marathi family, Brahmin family. Prabha Chandrachud, a classical musician who sang for All India Radio. Now, that is the background with which the great Lord is coming up. And his education, DYC was born in Mumbai on November 11, 1959. He graduated from Stephens College, Delhi, with a degree in economics and mathematics. He then earned a bachelor's degree in law from Delhi University in 1982, and an LLM from Harvard University in 1983, and a doctorate in judicial sciences from Harvard University. Actually, even though he is not a qualified in software, the amount of knowledge that he possesses in software, which is used for this nation, which I am going to deliberate, that is the issue. Now, the Lordship in a recent speech, he said, I find myself pondering over questions. Did I achieve everything I set out to do? How will history judge my tenure? Could I have done things differently? What legacy will I leave for the future generations of judges and legal professionals? He said. More importantly, to the nation. The nation sooner than later will realize the fruits, just like the Benjamin Franklin did for the world, the Lordships did for the country. And what Mahatma Gandhi said, he is surrounded by love. When he was delivering the electoral bonds, there's one gentleman by name some Jayesh Mehta. He made very abusive comments against the Chief Justice. He was trolled, Chief Justice. But Lordship in a meeting said that he expressed his anguish, but he never took any action. Any action. That's the kindness, highest of the kindness. And now this next is, he set goals. See, whenever you take over as the Chief Justice of India, the highest court of the land, the leader of the highest court, he sets certain standards. When he raises that question, what did I achieve? Then always, what are the standards, what are the goals he set, and what are the actuals against which we can test it. And I've taken only part of it. All of you would have read it. And the Lordship's little time taken for this.
To reach out to the people instead of the people reaching out to the courts in their quest for justice. To ensure that the courts reach out to the people, it is essential that the process of litigation is simplified and made citizen-centric. Though the judiciary's engagement with technology gained prevalence during the COVID-19 pandemic, we must not dismantle the infrastructure but build upon it. And I would earnestly request the Chief Justice of the High Court to ensure that the technological infrastructure on which public funds have been spent is not dismantled, but strengthened further. The Supreme Court now functions in a hybrid mode, with both online and offline courts, which enable lawyers and parties in person to appear from different parts of the country. Though the Supreme Court is located on Tilak Mahal, the Supreme Court is a Supreme Court for the entire nation. As the Chief Justice, I am attempting to adopt technology-based services in the listing of cases and court hearings so that institutional flaws such as delays in listing and hearing can be removed from our vocabularies. The Key Committee of the Supreme Court of India uses technology to make the justice delivery system more accessible and citizen-centric. The National Judicial Data Grid is a repository of 77 lakh judgments of the High Courts that are available to every citizen free of cost. Additionally, various citizen-centric services are employed to reach out to the people at the grassroots level. While technology has ably aided us in ensuring functionality of the judiciary during the pandemic, technology must be augmented with institutional reforms to resolve the chief issues of access to justice. The first interface of the people with the judicial system is the district judiciary. It is thus of paramount importance that the district judiciary is strengthened and supported. The district judiciary must be lifted from the mindset of being a subordinated judiciary. Today, the Honorable Prime Minister of India is present here to launch the key initiatives, namely the virtual justice clocks, the Justice Eyes mobile application 2.0, digital courts, and S3 VAS websites of district courts. The virtual justice clock is a platform where information available through the National Judicial Data Grid is made available to the public. Virtual justice clocks for the District Judiciary of India are a real-time informative public dashboard which provide information. The app is provided to judicial officers to monitor pendency and disposal of his or her court at the handset 24/7. Digital Courts is a green initiative of the Indian judiciary in the form of a desktop app that has been developed to make courts paperless or digital. It provides an easy-to-view case files documents while sitting at home. Judges can view all the case-related pleadings, charge sheets, court orders of both civil and criminal cases which aim at making the court paperless. And finally, the initiative S3 VAS website. The acronym S3 VAS stands for Secure, Scalable, and Sugamya Website as a service. Through the Digital Court and S3 VAS initiatives, the websites of district courts are being upgraded from the existing system to a platform which is secure, scalable, and accessible. Content published on the website is accessible so that even persons with disabilities, including visual disabilities, would be able to access the information using include. I would like to emphasize on the relevance and constitutional values, not just to the judicial branch, but to all institutions and sections of the society. The evolution of a society can only ensue on the foundations of liberty, equality, and fraternity, the trinity of values highlighted by Dr. Babasaheb Ambedkar in his last address to the Constituent Assembly. Therefore, I appeal to the young minds to reflect on the social realities of India and work towards achieving fraternity by dedicating themselves to the cause of justice in whatever way possible. Sometimes change happens by small acts of kindness. The heart and the soul of law, as it is administered in our courts, is our sense of compassion to our citizens.
So, dear friends, you have seen that what are the targets Lordships have set, and the focus was on the digitalization, reaching the common man, the justice. It's not so simple, though he set the standards at that point in time. And when he's now remitting the office, the first part, there are two parts to this access to justice to the common man. One is achieved, infrastructure, everything which I'll discuss. The second is the monitoring aspect of this, which will give wonders to the needy people, the poor people who have no access to justice in the present system prior to Lordships taking over. Now, dear friends, before we take up, I'm Venkat Shivkumar. I'm actually a professor, more observing. I've trained more than 10,000 successful chartered accountants who are in over the entire globe in very big positions. And I would like to share the issues, two issues I would like to say. That is, what were the troubles I observed from my side of view? It is not a simple matter that VC hearing is online coming. During the Lordship's tenure only, the constitutional bench started telecasting through YouTube. That was a very great thing, unimaginable. Then followed by Gujarat High Court, Karnataka High Court, Madras, the Madhya Pradesh High Court. And we'll see that now VC hearing has become mandatory by judgment of Hon'ble Supreme Court, Justice Murari. And the latest judgment, Lordship Constitutional Bench he constituted when there was a Karnataka High Court judge's issue. He said they have stopped that, the judges ordered to stop that telecast because it is coming to light of public. But Lordship said, that's the word that makes him Father of Justice before he lays down his office. He said, if you say problem is light, then you need to have more light to solve that problem. So this is my observation. It's how we handle these difficulties I would like to share because I want to speak 2 minutes about the problem solving and made it happen. Yeah, Lordships is leaving the this thing, but he has to be with us. It is not a fully done job, but then it is protected. That VC hearing is going to be there, digitalization, all that I will explain. That is because I felt it. Therefore, I wanted to make this. First, what happened, Justice V. Ramar Subramaniam was there. He's a retired Supreme Court judge. In 1985, we both were given in charge of reviving a company. He was a legal advisor. I'm a chartered accountant. I was practicing as a finance team. Then the company was besieged with all types of problems. Income tax problem was there. No money was there. Banks were attacking them. Workers, union strikes were there. Then the chairman thought, we were very young. And chairman thought, these two people will do the job. Because I first joined as a finance controller. Then he came in. We both were there. Then he's very intelligent. He told me, "Here, Shiva, you do one thing. There are so many problems are there, we cannot concentrate on all problems. There will be one key problem will be there. If you solve that, all the problems will fall in place." That is how a sick company or any individual facing too many problems, he should not think that too many problems. Identify, that is ABC analysis in costing, they say. Which so we found, then he told me, what is the A class for this, you tell me. I said, no, they don't have cash. Therefore, they need working capital. So we have to go to the chairman and get the working capital. The funds should be such to generate a turnover, which will generate a margin to cover up all the fixed costs. That's one side. We cut down the existing lavish fixed costs, and then we'll try to plan out the surplus, and then we'll repay everybody, handle this. That's what we did. And the SIG company became so big, it won the national award, Orient Marine Company. And another point I would add, why I took teaching is another issue. Both of us used to come after that, he comes consultancy, used to come down in this opposite to the High Court of Madras. Our office was there. Then one gentleman met us, or a very saintly person. Suddenly he saw Ms. Ram Subramaniam and told him, you will go to the highest place of this country as a judge. He is a simple lawyer struggling. And then I asked him, what will happen to me? No, you will become a teacher, he said. Then we believed that. I took, of course, I had a great passion for teaching. So I left the job and then came. And even when he was about to be elevated to Supreme Court, he was asking me whether it will happen. And I'm at 40, that is, he was in the rank as 42. I think so. He was telling me, I don't remember. There's another person, another learned judge was there competing at 2. So I said, no, you are going to become Supreme Court judge, don't worry. And it happened. So there are a lot of issues which we would like to share. But this is based on a lot of discussions with many people. It is not just what I felt whenever I appear in Delhi, Supreme Court or the other courts, how the people rate intellectuals at various things. But for me, he is like a god because I'll tell you why. Access the Supreme Court is the easiest thing now anybody can do. If you want to prepare SLP or a statutory appeal, just it may not take more than 2 days time. The system is so perfect that you just have to, all this is set. And I read, I viewed the speeches of Justice Abhay Oka. What to write, what the judges will look at it in advocacy. Beautifully he spoke. Synopsis, list of dates and events with evidence, you link it. Even 10 grounds are there, you write 2 grounds. Then automatically the matter will be settled there. Like that. So you can even, we would like to, now we are trying to teach the lay persons, young lawyers who did not have the knowledge to, resources to study in elite colleges. So we want to work for them. I have a team of PhDs working, all of us together as a team. So this is the object with which we studied the entire. Now it's very, what is the advantage of 2 things? Access to justice. It is very difficult to file and get a petition listed in a Madras High Court. But it is so simple to get the appeal filed and listed in Hon'ble Supreme Court. And the perfection means digital, the officials, we may not be, you can contact, the numbers are there. They are so polite, they will help you. And if you do any defectives are there, they'll immediately correct it. There's no need to meet them, all virtual. And the cost of accessing, if it's a criminal case, no fees. If you're a part-time person, free. And if you're the statutory appeal, 5,500. Civil appeals, 5,500. Nothing more than that. You can sit in your house, you will get a VC hearing, and the judge is beautifully, the technology is so good. No sounds, perfectly it will come. At least because in the Supreme Court, when your case is admitted, first admission you should go, and then final hearing you can go. In between, you can appear before the VC, and the judges are so kind, so kind. They are real angels, which I felt. And that is the what is the legacy? He's asked the question, what is the legacy with which I'm going? And this is what done. Now, if the law percolates, Bapuji got us independence, freedom from the Britishers. But what freedom we have? You can't access the justice. I'll give you an example, dear friends. If you file in a magistrate, in magistrate court at Chennai, in one place, you can't enter. No new lawyer can come. Only the existing lawyers in that bar only will be allowed to. When any new persons come, they will beat you up. Recently, news came, so many times came. See, that is the cartel type of thing is. Thereafter, what the judge will do, if you are a honest judge, you will be finished. It's a like that. Then, that extent, then the judge is, suppose, for example, normally what happens, you are a common man, you are suffering because of the dominance of the rich and mighty and powerful. Correct? Now, the rich and mighty, if you file a case against them, then what will happen? Then they will immediately go to 482. This happened to me in a case where the learned magistrate of Saidapet, very brilliantly, madam, 17th High Court, and took all precautions. The magistrate court does a very good job. They're always under the scared of the top influences and all. But they are so knowledgeable. There's no infrastructure for them. But still, they work with, till they type themselves. And up to 7 o'clock they work. But they are so sincere. They can understand the criminal law so well. Then Lordships, the Honorable Learned Judge issued notice. When the notice, summons issued, after due process, double checking, triple checking, because the case of top people. Then when the summons issued, then nobody comes before the MM court. Straight away they went to 482. And then stay is granted. Stay will be given to them without their presence. Nobody knows when the matter comes. They will appoint the topmost lawyer. He will tell something. They will partly he will tell. Nothing mislead. Something is there. Stay is granted. Then they wanted to immediately, when stay is granted, nobody will come back. But they wanted to get it done. When the matter came, I appeared and the other side appeared. The judge is very popular judge, lecturer, top class. But when he saw me in the online, I was appearing. Online in Chennai is not good. A lot of sounds will come. Judges will not entertain online. And they will not entertain. They will see that you come there and talk. This is the problem. And then I was telling Malats, that man was telling, this is the judgment and this is the judgment of NCLT. And I was about to say, no, you file as notes of submissions, we will read it. Then it was dismissed with adverse comments. And later I told her that was dismissed based on a judgment which was dismissed by appellate court. Then I told the lordships, you have passed all that comments against me based on something dismissed. Oh, I see, you go to Supreme Court. Now there is no review power under 482. I said, no, my lords, review power is not there. Recall power is inherent power, settled by the constitutional bench. It is inherent power. If it's a CPC 151, there is a inherent power to recall. If it is a writ court, recall power is there. When review power is there, you apply. That is a statutory power. If it is not there, recall power is an inherent power. So, but then it is dismissed. But Supreme Court, 2 minutes, 2 days, we have filed and put it in defectives. Then within 3 days, 4 days, that will be numbered. It depends on you. It will be listed. And if you know the tricks of this thing, we want to teach others, the party persons everywhere, to help them what the judge wants. And it becomes extremely easy. And the VC hearing, if you are going to record that VC hearing, where we mentioned the judge, lordships, this is what has happened. Oh, this has happened. Okay, you go to Supreme Court. That's all. When the judge just gets the Hon'ble Supreme Court judge comes, SLP criminal is come, then he is clear. There is no need. And you can see, which we will discuss. Recently, Karnataka High Court, one learned judge was, you all know that. That's where the Hon'ble Supreme Court constituted a constitution bench. And then they took up, immediately the lordships, the judge apologized for it. Immediately, Karnataka High Court stopped. They passed an order stopping the video hearing, public hearing. Then also said, remove all clippings. Then lordship passed an order, the constitutional bench. If light is the problem you're saying, more light should be there. Don't do all that. Today, all High Court rules will become defunct. You understand? So, this is how monitoring becomes extremely important. So, lordships have done a great job. And I'm going to part 2. We are going to cut it into 2 parts. But this coming as full. Now the justice. This is the tribute to Dr. DYC. Just the photo will speak volumes about the greatest, is a greatest of the human beings, a kind judge, and nothing more I can speak. There's no need for me to speak and all. And it is you see, who is a God? And you know, I'll just take you to Ramayana. Lord Ram, after killing Dashrath, he will come. Dashrath will come and tell. After killing Ravan, Dashrath will appear. And Dashrath Maharaj blesses Ram, my son. Everybody in this Swarglok say you are Sriman Narayan. And but for me, I want you to be my son. The Ram will say, no, my father. I am always son of Dashrath. And for me, the God, the destiny has ordained some duties. I have done it by following the path of Dharma. I may be successful, I may not be successful, but under no circumstances I will move out of Dharma. And if you realize that, you are the God. There is no God. It is you, the God. Atma will meet the Paramatma. So that is why I have considered the lordships from a various angle. If you test and put this in the father of access to justice. Now, there's a lot of publications came, bar and bench also wrote. I picked up from that. And what is the digital thing? Traditionally, bundles of files, Lordships already spoke in his speech as a goal, but this is what he achieved. Traditionally, bundles of files and papers in the courtroom have always been a symbol of knowledge and wisdom for centuries and accessible to select few. Select few. What a beautiful word is. However, in the contemporary digital age, technology has increased the transparency, breaking of the confines of legal knowledge with the physical courtroom. The VC hearing teaches you so much. The greatest lawyers come and argue. What judges want, full of knowledge. And it is a great feast of knowledge. And now the next one. In his book, The Future of Law, Richard Herrick foresaw technology revolutionizing the legal field and transforming the court system. The ongoing technological revolution in the judiciary is evidenced by the e-courts mission. So, next. The subcommittee appointed by the e-commerce committee of the Supreme Court of India formulated a standard operating procedures for scanning, storage, digitalization of court records. The standard operating procedures endorsed by the Supreme Court e-commerce committee under the Chief Justice DYC on October 21, 22 was directed for implementation in all the high courts and district courts by the Supreme Court division bench led by Justice Krishna Murari. He's a god. Krishna Murari and Justice Sanjay Karol are just gods. Otherwise, you get a chance, it will be closed. VC hearing is the first casualty in high courts, as you saw it in Karnataka. And then the subcommittee appointed by the E-Committee of the Supreme Court of India formulated standard procedures. Supreme Court has there. Then, And then 218, the Supreme Court, through the decision of Swapnil Tripathi, was the Supreme Court, allowed live streaming of constitutional matters and cases of national importance. The Gujarat High Court made the first step in July 21 and became the first court in the country to live stream its proceedings. Later, it was followed by High Court of Karnataka, Odisha, Madhya Pradesh, Patna, and other high courts. Now I discussed about how the criminal jurisprudence, if you see earlier, there is no justice. You come to magistrate court, and I told you, then the High Court doesn't bother. 120 cases, the judges are also under great strain. We cannot find faults with them. They are very great judges. But the pressure is so much. And they think the senior counsel comes, he will speak correctly. Let us believe him. And this fellow is a 14%, doesn't know anything. And once it is gone, you can't go to Supreme Court. That's all. Very costly. NCL 80 was also extremely costly because you have a statutory appeal in NCL 80. And but where you go, you have to catch some advocate on record. You have to catch somebody, and they have very difficult procedures. Earlier means listing is impossible. 50,000 will take place. Even you go and appear. And when you go, I went in NCL 80. There you go. I asked some lawyers. They said, no, you go there, case will not come. You will waste whole day or 2 days. And so much cost to the client in going by plane, staying in the hotel and come back. In my case, morning you go there. You have to go 4 o'clock and go there. And there the judge will be sitting. And 40, 50 cases will be there. They'll take 3 cases, 5 cases. And the tribunal, nobody is bothered. They will pass orders they like. They will pass orders they like. I'll give you a simple example. Because now that VC's hearing is there. In Hon'ble NCL 80, there's a very big case. Now it's before Supreme Court. On that day, we are asking stay. And the High Court is, stay order is there, Madras High Court. So before me, one case came for admission. And condonation, delay condonation petition came, and thereafter the judge saw, senior counsel was there, allowed stay. If you, without condoning the delay petition, you gave stay. Then the next case came. Then there is a stay in that. Then he said, what is the jurisprudence of stay? Lordship said, he is a judicial member there, over 4 years he was there. And he said, the stay means you are standing. And stay means you never go back, never go front, never goes left, right. That's all. That is called stay. And he immediately will give cricket match. Lordship will take some match where Pataudi is bowling, Pataudi is batting or bowling and kicking. And thereafter CPC. Then it will go for almost 1 hour. 5 cases are being heard. And thereafter my case came. I said, Lordship, you, no, stay will not be granted to you. I said, no, just now your Lordship said stay means what? High Court, Constitutional Court, Tribunal is not lesser. He did not give. This is not for me. It is just a play game. And you should be prepared with a cricket match. You should know who is Pataudi, who is Sachin Tendulkar, what is CPC order 2, 4, 5. And 5 cases per day. And once you give a stay, next 3 years only the case will come. And this is a legislation, time-bound resolution. And everybody is talking, you have not reached the time. But there is no monitoring. That's what Hon'ble Sundaresh sir said. I'll show you his speech on functioning of tribunals. So therefore, this is all because another problem here is we are going to monitoring. Honorable DYC did the great job. But then the second part is still gaps are there. Monitoring is there. Who will bring it to the court? If you take the Karnataka High Court, it is viral, it became because of EC hearing. And then the judges saw it. And then they called it. And then Bar Council said, no, this judge is practiced to speak something not relating to the subject. Who will talk about a judge against judge? That is the end of his career in that court. And if it's a tribunal, you are staying 5 years. Impossible. You have to. The lawyers are the people who are supposed to know everything, but they cannot come out. The greatest in Chennai, brilliant judges, lawyers are there with fund of knowledge. They are humiliated. Tribunals and all. You have to see daily it's like writing exam. For me at least, teacher, I'm finding difficulty writing exam and the test will pass. You don't know the certainty of law because same facts, different judgments. Then where you will go to Supreme Court? What a cost Supreme Court earlier. And now the fear of Supreme Court itself is making everybody cautious. And you know what happened? Within 4 days, the matter is solved. Earlier came long back, if you see, some 2 lawyers filed a case against a constitutional judge and against one PhD doctorate law. But it went 10 years and finally nothing happened. Because this is a real evidence that you have. Injustice is done to you. And you can see, as Lordship said, that public confidence, public are watching. In an era of social media, one has to be extremely careful. These maybe 1 or 2 people are like that. But there will be more great judges are there. Remember, once you sit in that place of God, that Karnataka we have shown, you get that divine powers. And this I have explained. And filing appeals I have explained. Now, Honorable Judge, this is the advantage that is created for the nation is this. The litigant is no longer in darkness about his case and the service of his counsel. Earlier, you don't know what your lawyer is telling. What he tells is the gospel truth. And you don't know who is the other lawyer also. If suppose I want to know who is the good lawyer in, I will only know 5, 6 names charging 5 lakhs to 10 lakhs per hearing. I can't bear. And this is gone. The litigant is no longer in darkness about his case and what the counsel is doing. The cartel of the advocates and the judges' nexus gets weakened. Advocates only. Judges may be very good, but the strength of the advocate can do a lot of things. I don't want to go into that. Because it is the judiciary, the guardian angels of this constitution, protecting our freedoms. And therefore, we cannot, we have to treat them as God's own. Whoever it is, they may be passive. But ultimately, that system has to survive. Now, today you don't know. Suppose I am a just passed lawyer. What is that? Anybody can pass law. It is like Arun Jaitley was giving us a lecture. He said, his father asked him, you please choose 2 courses are before you. One is law. Law means very difficult to fail. CA. It's very difficult to pass. You choose. He said, I chose law. But then law is something greatest. It is when you're practicing lawyer, advocate, he has to have such great knowledge. You can see and learn from the great lawyers and the judges who are these things. And for me, I was with Ms. Ram Subramanian, is one of the brilliant brains. And I used to listen. That's all. My knowledge is very limited. Now, you can see this, the abusive and errant judicial officers will not behave the same offensive manner before. Because before it doesn't come to light. Now, the effective monitoring system is what is missing. If you introduce that, the controls, I have developed certain better controls. One of that is, suppose if you are hit by the judge's behavior, you have a committee. Suppose tribunals are there, judge is very harsh, you believe. And then you record that. Then you send it, you can ask for corresponding thorough recording so that the tampering issue is solved. Then there should be a committee. You send it to them. The committee comprising of High Court judges supervising the 227, and then the Honorable NCLT President and some that dissection. And level 1 scrutiny, level 2 scrutiny. And then whatever the process can be introduced. Once you know that is happening, it is not just the misbehavior, the timings, the way in which adjudication takes place, the knowledge of these people, and what is happening, all these things will come. And let's go to what lordships have said. Honorable Justice.
I think we have to work towards bringing the tribunals back. Most of the tribunals should come back to the High Court. You know, somehow the performance of the tribunals are not so great. We have to get back to the because tribunals run into difficulties which I am seeing, which I have also put into the central government before some hearings. There is no accountability there. Number 1. There is no qualitative disposal there. Number 2. Number 3 is a cost. Accountability, but they're not amenable to 227 in many cases. Power of superintendence in there. What will be and 4 years? Otherwise, we can increase the number of judges here and create some more benches. We can bring more changes at the control. Already, specialized tribunal, we can suppose custom tribunal, we can have one custom member also along with the judges. No difficulty, but we can High Court control. I only beseech all the association to think beyond. Think in the Girkra Sunila, what Patu was single shaped, single shaped.
So, Honorable M.M. Sundaresh, a wonderful judge of Madras, our judge, and in one of our personal meetings, book cutting ceremony, Lordship was hearing me for 45 minutes on how the tribunals are functioning. He was such a kind judge. Unfortunately, he refused to hear my case in Supreme Court. But the like, you know, what happens is, suppose the ASD comes and makes some adverse reference to me when appearing as a parting person. Lordship used to tell him, no, he'll come so well prepared, Mr. Venkat Shivakumar. We have full faith. Let them notice be served. And Lordship, so concerned. He was asked recently, I was hearing, what do you think about Justice DYC? He said, many people think he is right. Some people think he is left. He is neither right nor left. He is straight to justice. The justice dispensation in the best possible way he is. And same thing, Lordships in Madurai. Madurai recently spoke about Sengol, that is Kannagi. And of course, Lordship's knowledge on Ramayana is so excellent. And yes, next. Now, dear friends, this is one thing before I would like to share it with you. This is a case where I appeared. And my case is crystal clear, where the respondent who filed the case admitted that he had made wrong. The matter was heard long, and after that dismissed. And the judgment passed is nothing to do with the issues raised. And I was telling them it's before the Hon'ble Supreme Court was going to decide. But then it was dismissed. The prayer is not what is the prayer. The relief dismissed is something, and the prayer asked is different, and all. So the judge is a very intelligent, good judge. So I thought maybe it's a mistake. So I filed a review petition. And the review petition has not come for hearing for long. Then when it came, you can see. And the review was admitted. But again, it is dismissed. Now I have to go to the appeal court. There's a lot of cost is involved. One of the reasons could be the judges are highly pressurized with too much of work. Too much. Big lawyers are coming. And party in person is there. They won't bother about it. And you can see, it is not as a complaint. But why I put it like this is, suppose if this sort of things, suppose I am going to Supreme Court, this is the appeal. I will write this happened, that happened, books and books it will go. Instead of that, this is my case. The material evidence ignored. The law that is applicable has been ignored. Therefore, the judgment is wrong. And hence appeal should be allowed. That's all my case. But then how can you prove it? That is why I'm saying the monitoring, as Justice M.M. Sundaresh sir was telling, monitoring. And so that the strain will be reduced. You can see what exactly happened. And
Okay, years, 15 years. No, I consider the judges, where do you want to thank the court? You guys, that's it. Then what is this? Where do you want to thank the court? If you feel it is not correct, I will not do that. Yes. No need to thank the court. Yes. Yes, thank you. That's all. See. Okay, years, 15. This is a review petition, my lords, against the writ petition wherein the IBBI passed a disciplinary order which was under challenge. The constitutional session verified unanimous. Is my lord? No, I will, page 13, my lords. I am strictly confining to the grounds laid down by the Supreme Court on the review. And here, my lords, let's go to the lords, page 13. These are the grounds on which any petition can be sustained. A. The errors which are self-evident and can be detected easily without even going into the detailed hearings. Reasoning. This is what is the error, sir? What is the error? It is what is the error? I show page 58. So, page number 58. I'll just brief you quickly, Malus, or you I'm coming to the subject, Malus. Because here there is an allegation, until points there. I am coming to a point, my lord. Yes. This is a violation of regulation 7A. And the regulation 7A has three components. and tell what the error committed in the order. The court is ignored all that completely. They want to appeal. Nine, sir, it's come to Supreme Court. So let me tell you, they have already listened to me, lordships. They have filed it, saying that it's vindicated. The lordships have seen, and they came to the conclusion. They said we will take up at the back, talk on board or 10th line. I just want your lordship, you're so brilliant lords. Therefore, kindly consider, see that and pass any order. This is I'm not bothered. But here, Regulation 7(8), error apparent, my lords, when I have applied, within 15 days I should get. If you have not got in 15 days, my lords, it is deemed to have been issued. That's my case. And it has been, see, lordship, you can see, you yourself, lordships, page 15, you have written in the order. Please see this. This honorable court, while on one hand not considered the material evidence, that's for appeal, relied on the third respondent's averments as under lordships written like this. Therefore, the third respondent made inquiries into the qualifications of the petitioner to act as a liquidator.
For which, yes, notice order, yes, next.
Is dismissed, lords?
Notice order, sir, not dismissed, sir.
I'll be grateful. Thank you so much, my lords.
Now, this is the electoral bonds case. And
CI's attitude appears to be, you tell us to disclose a particular detail and we'll disclose it. That's not fair process.
Not how we understood.
Yeah. This is the judgment of the Supreme Court. As chairman of the State Bank of India and duty bound to comply with the judgment, I will disclose every part of the information which is in my custody, directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, I mean, State Bank of India has the best legal advice open to it.
now, friends, this is the Honorable Supreme Court Judge. If you see the speech on access to justice, the Lordship is looking the subject from a different angle. There are two parties to the litigation adversarial process. One is petitioner, appellant, another is the respondent. But there is an invisible litigant, that is what Lordships have brought in. Where this is a beautiful case, you all have to read the speech, the is incarnation of God, you will feel it. It moved my heart. What happened is one person had 3 girl children and he wanted to have a boy, the 4th one. But then unfortunately the same girl was born and that person killed that wife for 4th girl. And now he went to jail and the 4 people have become orphans. Their relatives wanted to take over all the properties. The Lordship took it as his responsibility, and then how this is written by Pradeep Rai's thing, you can see 8 minutes video, but we cannot proceed it. So the most of the judges are so kind-hearted persons. I'll just give only one few minutes of that lecture.
That the concept of access to justice, legal aid, legal services cannot be implemented mechanically through rule books or through prescription. It has to be imbibed in the mindset that there has to be a commitment by individuals forming a group and then take it and lead it as a movement.
Now, in spite of doing such a great job, Lordships is asking, as my tenure is coming to end, my mind has been heavily preoccupied with fears about the future and the past. I find myself pondering over the questions such as, did I achieve everything I set out to do? How will the history judge my tenure? Could I have done things differently? What legacy will I leave for future generations of judges and legal professionals? And more so the common men It was omitted in that. Now you can see the answer by Honorable Justice Nagaratna Madam, who is going to be the future Chief Justice of India.
I must express my deepest gratitude to Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, for his leadership imbued with compassion and sensitivity in cases and initiatives targeted towards justice and children. I request that we all give a standing ovation to our Chief Justice for his guidance and for his experience. Thank you.
Now, friends, may God bless him. It's just he's a 65-year young person. The nation needs Lordship, and family should be blessed by Lord Venkateshwara Balaji always. I'll close this with this.
Sadam Bodhivasam Gala Pushpavasam Jagat Sannivasam Shatatavasam Gala Jatishatram Lasatitavastram Lasachari Lakram
Thank you, dear friends and brothers and sisters, for watching my video. Thank you very much.